Welcome to this Universities UK International webinar on data protection and the no-deal Brexit, with me, Andrew Cormack, Chief Regulatory Advisor at GISC.
And me, Udalak Data. I'm a solicitor and legal director at Recital.
Probably unlike anything else in Brexit, the effect for GDPR is relatively straightforward because it comes down to one fact that at some point in the process, the UK will become a non-member state, or what in data protection terms is called a third country. The significance of that for data flows is probably easiest to see in a diagram. So at the moment, between the UK and the rest of the EU, because we are all members of the Union, there is complete free movement of data. Because the EU is regarded as having very high standards of protection of personal data, most of the rest of the world is also quite happy for its citizens, its individuals' personal data to come into that regime. So there are one or two countries that disagree with that, but rather few. The big restriction is if we or anybody else in the EU wants to send data out to the rest of the world. And there are very strong restrictions. So the red arrow. As and when the UK ceases to be a member state, that picture changes a little bit. Still the same, the UK government has said, for outbound traffic from the UK. So we will still regard the rest of the EU as providing adequate protection for UK citizens' personal data, and we will regard the rest of the world as not, by default, providing adequate protection. Similarly, it seems unlikely that there will be much change on other countries' views of sending data to the UK, so that arrow probably stays the same. The big change is on transfers from the EU into the UK. That is now a third country, so that is now also a red arrow. So the difference at the moment, we only see the red arrow from the exporter side. In future, we have to worry about the red arrow from the importer side as well. So what's in that red arrow? Anybody sending data down the red arrow, so the duties fall on the entity, person, the organization exporting data, is required because the receiving country is considered not to provide adequate protection by default. The exporter must ensure the protection of the personal data to a European standard. There are a number of different options in the General Data Protection Regulation. The most likely options for education and research depend on who chooses whether the data flow happens or not. So in situations where it's a student's choice, so for example, if a student decides they want to study abroad, or an applicant's choice, so somebody from the continent who wants to come and study here, probably the best basis is necessary performance of the contract with an individual. And that is fairly detailed provisions on what has to happen in those cases. Or if it's additional information that isn't actually necessary for the performance of the contract but might be useful, or an applicant, somebody before applying is asking for information, so there's no immediate likelihood of a contract being formed, you would look at explicit consent. Both cases, you need to make it clear to the individual that their personal data will flow to a country where the safeguards are not as they may expect at home. In particular, that they can no longer rely on being able to raise a complaint with their national data protection regulator in their home language. If they have a complaint against a UK data controller, they will almost certainly have to make a complaint to the UK data protection regulator in English. Other changes, probably less significant than that, but you have to notify the individual that they exist. If, on the other hand, it's the choice of an exporting organisation to send personal data into the UK, the most common basis is going to be what are called either standard contractual clauses or model clauses. And where you have a partnership with a European university, you would want to, you need to include those clauses in any agreement with those partner organisations. Possible, but I think in the short term unlikely, there is a provision where you have a group of institutions. This is primarily aimed at multinational companies, but the definition is actually engaged in a joint economic activity. So this might extend to looser partnerships. There's a thing called binding corporate rules. These are very heavyweight and they need to be approved by a data protection authority. One of the tricky bits about Brexit is it will mean that the UK Data Protection Authority is no longer eligible to approve binding corporate rules. And it turns out that so far they have actually been one of the most enthusiastic approvers of binding corporate rules. So you may find it quite challenging to find an overseas regulator who is familiar with the BCR process. But that might be worth looking at if you've got a long-term close relationship with entities in other European countries. Why should we care? You know, is this just a matter of legal formalities? Probably not, because there are three different groups of people who might complain, might object if we don't comply. First one, member state regulators. So if a regulator in a European country sees data being exported to the UK, which is a third country, without the appropriate safeguards, they have the power to order those exports to stop if they don't see them being safeguarded properly, or indeed they can fine exporters. That would be quite a long process, and you'd get a fair bit of warning of that happening, I think. Probably more likely in the short term is that organisations who you hope will export data, continue to export data to the UK, will be reluctant to export unless they can show their national regulators that that export is covered by the appropriate safeguards. Might be three reasons: sanctions from their own regulator, but see previous discussion. Under the GDPR, data subjects can make class actions in law, not just individual complaints. So potentially there are quite big costs there if you get it wrong. But actually I suspect the quickest effect will be a risk to reputation if they are seen as handling their personal data in an unsafe way by sending it to the UK. You just have to think back over past years about criticisms of organisations that have sent data to the US and think in future the UK is going to be in the position that the US is at the moment. And individuals who may well look at the UK and say they have left, they are no longer part of this pan-European arrangement. We are not happy with our personal data going there. So that may in fact be the quickest, the individuals and the organisations, probably quicker than the regulators. But there are quite speedy effects could occur to stop or limit the amount of personal data coming to the UK. Some scenarios that are common in research and education. Research using international personal data is already a mess because there are research provisions in the GDPR, but they are very high level and they allow each individual member state to say what are the rules, in particular what are the appropriate safeguards. So those are already going to fragment and already be different for transfers even within Europe. There might here be an opportunity for UK funders to help the rest of the continent to develop some sort of standard approach for research. Otherwise, it's going to be a matter of agreement between individual partners in the research project. Exchange students, both directions. Probably if you've got, if you are receiving students from the continent, expect their home university to expect standard contract clauses. And in the opposite direction, you probably want to have standard contract clauses because that will allow perhaps transfer of a bit more data than is absolutely necessary. If you rely on necessary for contract with the student, so you are teaching a student a course that involves some overseas study, you may not get much data back from the institution that you send them to, because they will be pushing on the word necessary in that situation. Using cloud services, probably the one that I'm asked about most and the one that regulators have said least about. The UK government has explicitly said it is happy with UK organisations continuing to use cloud storage in the EU and in fact the European Economic Area. On the other direction, so if you can put data into the cloud, fine. If you want to bring it back, that could look like an export, but that situation has existed since 1995, or wherever you think the first cloud service in the EU existed, and no regulator, as far as I know, has ever expressed concern about it, about bringing data back. Certainly the Irish regulator, who's probably the one of most interest, as a lot of clouds are in Dublin, is completely silent on retrieval from cloud in all their statements about Brexit. So I don't think this one's going to be an issue, but it's something to keep an eye on. So preparing for Brexit, actually whatever flavour, since we're recording this on the 18th of October, we really don't know what flavour of Brexit is going to happen or when. So we're trying to cover everything. Where possible, where you've got contracts, put the standard clauses in. For individuals, and indeed for exporters, show how you protect data protection rights. Probably unlikely to say we are compliant with the UK Data Protection Act, because a couple of barriers there. One is that the European Court of Justice has twice looked at UK provisions on data retention and said that they are unlawful. And if you look at the judgment where the original safe harbour agreement between the EU and the US was struck down, you can pretty much pull out the references to the US law and put in references to the equivalent UK law. So those are two areas that you need to be aware that people may raise additional questions. Since, I say, it's the 18th of October, one option, one question might come up, can we just wait for a deal and an adequacy decision? They are both mentioned in the very latest version of the withdrawal agreement and the political declaration. Two issues there. One, is the transition period long enough to achieve an adequacy decision? Because typically those take 2 years would be tight. And as above, would UK be law found adequate anyway? So you could take that approach, at least as of today, but that's possibly just postponing the problem. And if it does go wrong, you'll have even less notice of having to bring in one of the other provisions. So, hand over to Freddie.
Hi. Thank you very much. My talk is about a separate part of the application of the data protection rules. So we have one issue, which is the application of data protection rules in the UK. But the second issue, which I'll be discussing here, is about whether, notwithstanding that the UK's data protection rules will apply to the activities of a data controller within the UK, you might nevertheless also be subject to the extra-territorial application of the General Data Protection Regulation as an EU piece of legislation. I'll discuss the following two ideas. First is to explain a little bit around the conditions for the extraterritorial effect of the GDPR, and also what are some of the consequences if the GDPR does apply, and I'm looking at in particular the appointment of a representative within the EU or the remaining EU states. I think by way of initial background, the General Data Protection Regulation applies not just to data controllers or data processors based in the EU, which is fairly straightforward, but also applies to processors or controllers which are either one where there is some data processing in the context of activities of an establishment of a controller or processor in the EU, and the second is in the context of the offering of goods or services within the EU. Now, this broadly matches the rules within the remainder of the EU treaty on the free movement of services and the freedom to set up an establishment in the EU. So there's a broad analogous relationship to the rules that are in GDPR to those regarding free movement in the treaty, and I think there's probably a lot of crossover in terms of the application of the rules and the interpretation of what is an establishment through the existing historic rules on what is an establishment, and separately on what it means to offer services within the EU with the existing case law on the provision of services. Looking firstly at in the context of an establishment, the key point is identifying whether there is an establishment, which means, broadly speaking, a stable establishment providing services on a continuous or perhaps permanent basis. And that could include, for instance, if there is a campus based somewhere within the EU, but all of the data processing might take place at the home institution back in the UK, or for instance, the European Data Protection Board has expanded that somewhat wider to include, as they've described, in some circumstances, the presence of one single employee or agent of the non-EU entity might be sufficient to constitute a stable arrangement if that employee or agent has a sufficient degree of stability, which is, my feeling is that that's slightly stronger, takes than the usual application of the rules on establishment, but that's something certainly to bear in mind, that can nevertheless bring the processing of the data of union data subjects within the ambit of data protection rules. The second area that we're looking at, is the application of the General Data Protection Regulation to the offering of services to data subjects in the EU. And this is certainly one of those areas that we need to consider quite carefully, and for clients to really understand very specifically what they are doing in the what activities they're doing in the European Union. And this kind of expanded to a certain degree with the recital to GDPR, where it makes it clear it's supposed to address the point where the non-EU entity is really targeting data subjects, customers within the EU area. And I think it's probably helpful to pick up on that in the context of some actual concrete examples. The ones I'll discuss are, the first and most obvious ones are about teaching research and the marketing of courses within the EU falls within the concept of offering services which are targeted to data subjects in the EU, and also the recruitment of candidates, and also marketing perhaps in a wider sense, which might include targeting donations from alumni and so on. Where we're talking about what I've called pure marketing, where the university has just got a passive website which is addressed to the world and is not addressed to any data and targeted to any territory in particular. It attracts students from maybe within the EU, but maybe also India, China, or anywhere else. And a student just needs to make an application to the UK-based institution. The European Data Protection Board can provide you with some helpful guidance, which is absolutely bang on point. It makes exactly the same kind of example in its useful guidance. It provides a number of worked examples to explain the different kinds of applications of rules, and where we are simply talking about a website, a kind of service which is not backed up by any particular target within any particular state or territory, then the EU Data Protection Board is reasonably happy that that would not fall within the ambit of offering services in the EU, simply because it's not targeted at all. There might be issues where we are talking about local recruitment. So if the university operates a network where there are local recruitment agents, or if the university operates, for instance, summer schools or face-to-face tuition in support of an existing course in a territory within the EU, then there may be more of an argument to say that that is directed at a particular territory within the EU. Separately, if we are looking at revenue raising, so more directed recruitment from someone which has a stable enterprise within the EU, that might fall within the concept of an establishment rather than the concept of providing services. Also, we probably have an issue when we're looking at if you are directly marketing for the purposes of soliciting donations, and there's a question there as to whether, even if the services are provided and the calls are made from the database which is outside the UK, sorry, outside the EU in the UK, whether that is an offer of services because you are actually targeting data subjects within the EU. So in summary, the GDPR applies to the establishment of an establishment which is within the EU, even if the control is based outside, and it also applies to offering services within the EU. And it's very important to understand in a very detailed and concrete way what activities are being provided in order to understand that analysis. In respect of the establishment within the EU, then GDPR will apply directly to that establishment. Where services are being provided within the EU, one of the consequences is that the non-EU UK institution will have to appoint a representative. So this is where Article 3.2 applies. This is the provision on targeting services. If you are providing services, so targeting data subjects within the EU, you're obliged to appoint a representative. There is a card out, a get out of jail free card for something which is described in the GDPR as a public authority or body. We'll discuss what that might mean shortly. And the appointment of the representative means really someone who is responsible for compliance with data protection as a point of contact within the EU. In terms of what is a public authority or public body, the definition in the Data Protection Act supplements the definition within the General Data Protection Regulation. In the GDPR, a public body or public authority is not defined, so we can look at it in a number of ways. There are again there's an analogous concept within the with other EU regulations, EU laws. So, for instance, there's a similar described body, a body governed by public law in the procurement regulations. I don't think that the same concept applies. I think it's quite a distinct area of law, and there are different. It kind of needs to be considered independently of regulation of public bodies in other EU legislation. In terms of the UK Act, a public authority or public body means those institutions which are defined as such within the Freedom of Information Act, which does include universities. Following some lobbying by the university sector, there was an amendment made to that definition such that a public body is only treated as such when it is performing tasks carried out in the public interest. And this was a government-backed amendment following lobbying from the university museums and galleries sector in order to avoid that universities, for instance, and museums and galleries are treated as public bodies for the purposes of soliciting donations and other tasks. So it would be, I think, quite unusual for the university sector to be treated as being exempt outside of the concept of public body for the purpose of soliciting donations, but within the concept of public bodies for the purpose of being treated as a representative. I don't think it could be Schrodinger's public body both simultaneously in and out within the same legislation. So we probably would have to treat that as being within the concept of public body for the purpose of teaching and research and performing public tasks, but probably not for those other kinds of activities which are not directly related. And that covers, I think, only part of the story. I think that only covers the position from the UK perspective, but the definition of the public authority or public bodies in another EU country, which will also apply GDPR, could be different to this, and under that legislation, the UK institution could be treated as a public body. That's a matter that you really need to establish under the legislation of the EU country in which the representative is based. So you could both simultaneously be not acting as a public body within the UK, but also acting as a public body in another EU member state. In terms of how this works, the university is required to appoint a representative, which has to be a person who will be responsible for liaising with the supervisory authority be following instructions. It will be different from a data protection officer who will need to be independent. The representative, on the other hand, is someone who is mandated by the controller, and there doesn't need to be any particular kind of formality. It can just be under a normal kind of service agreement that you might have with an agent who is already operating within the territory of one of the member states anyway. The general duties set out in Articles 30 and 31, which are about record keeping and cooperating with the supervisory authority. And there are, I think, in addition, a number of areas in which the UK will lose its benefit in terms of being part of the data protection regulation, but so which means that some of the guidance which will be applied to representatives will be developed through mechanisms which the UK is not part of, and that includes the cooperation between supervisory authorities as well. So in summary, the key issue is to have a detailed analysis of the activities in terms of providing services, understand what those are in order to identify whether there are any local formalities, and whether or not to appoint a representative within the EU.
Thank you for listening. We hope it's been useful.